Okay, ladies and gentlemen. Okay, we're here. We are here. We are back. We are back. Yes, we are back. And before you guys come up, we want to get the justice off the screen. Okay, we're here. We're okay, ladies and gentlemen. I was on another computer. It was acting all crazy, but I said let's move this to another room. Okay, so tonight, first of all, today we had a lot of things happening in the justice system with the decision that came down today from the Supreme Court, as well as Judge Glanville appears to have had a change of heart, and it would be it would be wrong for me not to have a legal scholar when we discuss this Supreme Court decision, as well as what's happening with this YSL case and the latest update, and the judge referring the case to another judge. But we have also the ex parte transcript that we're going to go over. And why not bring the legal scholar, attorney Al-Shabazz, to break this down, because she is very, very skilled in federal court, as well as she's a two-time college professor, former prosecutor, defense attorney. She's argued cases at the higher court and federal level. So I think it's very important to have someone up here that can do a breakdown on this very interesting Supreme Court decision, as well as let's go over this transcript, this from the ex parte communication. And I want to find out, has this transcript been redacted? Ladies and gentlemen, without any further ado, I'm going to bring up the incredible attorney Al-Shabazz. Good evening. What is going on? Where did she go? She was just here. Where she ran up and pulled up. Hold up. Good evening. How are you tonight? Oh, I can't hear you. Turn your sound up. I don't think your sound is on. Let's see here. I don't. Oh yeah, you're muted. Unmute yourself. Unmute yourself.
Okay. All right. Testing. 1, 2. Microphone check. What's happening? Oh God, I got too much happening right.
I don't hear you. What's going on?
I'm trying to get my life together.
Okay, you
so
good.
I can put these headphones on and
Okay, you good now. You good.
All right. Whatever.
What up? What's
up? What's going on?
We're gonna have to snip some of this out of here. So we're up late.
Hold on. I'm trying to get live on all the platforms. I think I'm on Facebook. For those of you who are following me on Facebook, I'm trying to jump on Instagram so I can tell people to come over to this. I got a couple messages in my DMs on Instagram asking me to talk about a few things. And I know I'm late. Because I think there were some issues happening in the YSL trial before that. What's up, Instagram? What's going on, family lamb? What's up?
We are live on Twitter as well.
We are live on Twitter. We live on Twitter?
Yeah, we are live on Twitter.
Oh, sucky now. We live on Twitter. I don't got nothing to do with that. I'm live on Facebook also. So and YouTube. I'm live on Facebook and YouTube. If you want to join us, you would have to come over there. I'm gonna leave this here so you guys can hear the conversation. I'll check back and forth if you have questions and or comments. So let's get into it, because we are talking about this on the late night. It's 10:55.
But in California,
just so y'all know, my bedtime is 11 o'clock. I'm not even gonna front. My phone gonna go off the alarm. Yeah, to remind me to take my ass to bed. Okay.
I appreciate you being on this late, and most people know that I'm not on this late, but because it's a Supreme Court decision.
Thank you, Mover. I was on. I'm sorry. Someone said they love me on Urban View. I was on Urban View this morning, Sirius XM. I was on the Larry Favors Daniel show. I'm on Friday mornings. No, don't do that. Don't play me. Do not.
I'm sorry. I ain't say nothing. I ain't say nothing.
All right, let's get to it. Let's talk about. We're gonna talk about first the biggest thing, right? That happened today.
Absolutely.
All right, let's talk about that first.
Decision, that 6-3 decision.
Yeah.
That essentially is making the presidents or former presidents or the presidents kings versus presidents.
Yeah. So I'm still working my way through the entire decision. I haven't read the whole thing. I've read bits and parts and pieces and whatnot. And so some parts of it is 6-3, and there's another part of it that's only 5-4, right? There's a part of it that's 5-4, where I think it's I'm not sure who didn't go along. I think it was Amy Coney Barrett. I think she didn't go along with part of the decision, but I got to go back to it anyway. In effect, what the Supreme Court has decided today is that the president, not just Donald Trump, but any president of the United States, is absolutely immune from his official acts in his office. I want to make sure that we're clear on the language right now. The Supreme Court said there is a presumption that official acts are that he's immune from those official acts, right? Now, when you hear the word presumption under the law, what that suggests is that that presumption can be overcome, right? The presumption can be overcome. That's all that means. It means that it's not an absolute thing, right? So in some instances, he has absolute immunity. In other instances, he has a presumption of immunity. And then they talk about private acts where he doesn't enjoy any immunity, right? So his private acts do not enjoy immunity. The problem is that the court does not define, and I haven't seen it in an opinion, the court doesn't define what official acts are.
I was going to ask you, can you give us an example?
No, which is why this is so frustrating for me as a law professor, because they are being completely hypocritical in their logic and in their analysis. From the Bruin case, if we go back from the Dobbs case, let's go back. If you remember, Roe versus Wade was overruled, right? A lot of people talk about it being overruled. It was overruled by a case called Dobbs. We call it Dobbs. I don't have the whole site. That's not important, right? In the Dobbs case, they relied on this idea that, one, you have to have textual support for fundamental rights, right? So it has to be enumerated. That's the language they use, right? Enumerated. That's just a fancy word for list. It has to be listed in the Constitution in order for us to identify it as a fundamental right. And they said abortion is not listed in the Constitution. It's not a fundamental right. Now, they didn't have to decide that in that case. In the Dobbs case, it was a challenge to a Mississippi statute that basically said we are going to outlaw abortion after 15 weeks. Mississippi said you can decide this case on behalf of the state, and it would not violate Roe. It wouldn't. But the Supreme Court says, you know what? Well, since it's here, since we're here, what we're going to do is we're going to go past what you asked us to do, which is the same bullshit they did today. We're going to go past what we're being asked to do, which is answer this question about this particular statute. And we're going to overrule 50 years of court precedent simply because we can. Simply because we can. And all of the reasoning that they use to overturn Roe, right? There is no historical record to support that abortion is a fundamental right. All of those reasonings, they threw out the window when it came to Trump immunity, because there is no historical record for any president having absolute immunity. In fact, that would be counter to what the founders were thinking when they formed the great nation, right? Because they were coming out of the type of government where there was a king. That was the one thing the founders thought, we're not about to be doing this king shit. We're not doing that. We're going to have a government. It's going to be, we're not going to have any one branch have any more power than another branch. That's why separation of powers is so important, right? And they threw all of that shit out the window and fashioned a whole new test for presidential immunity that didn't exist before. So are we relying on historical record, or are we just doing whatever the fuck we want to do because it's politically expedient? Because that's kind of what's happening right now.
I think it's more than politically expedient. I think it might be the direction that this country is really going in by having any president to have that type of power. His power the president's power just increased.
Oh yeah,
10 times
exponentially.
And that's Biden as well.
Of
so
course.
People understand this.
That's why I said not
Trump.
Trump. It's the office. It's the office. But you got to understand that this court, and obviously, you know, I don't have concrete support for this, but based on the actions of Jenny Thomas and Mrs. Alito, we know who they want to win, right? And so when they're writing this decision, I know who they have in mind when they're thinking about the type of president who will have absolute immunity. They're thinking about the next Republican president. That's what they're thinking about. They're thinking about Donald Trump.
And that's why it's a 6-3. It was definitely all of the conservatives that went that direction.
Yeah.
You know, and it's
I
troubling.
mean, are they beholding to him because he gave them a job? You know what I mean? What's up, family? I see you, Mikey. Simply Neek. Black Class Wars.
Ike, I would say that with the appointments that he made, I knew there was going to be some type of payday for him. I just didn't know what form it would have came in.
Nobody expected this level of expansion of the presidential power. No one. No expert expected this at all. Now, just to be fair, let's be clear that the case is not over, right? So the case is going to be remanded back to the district court where Judge Tanya Chutkin is presiding, right? And they have to now have hearings to determine whether or not the allegations in the indictment fit what would be deemed official acts. Right. So here's the rub. Here's the rub. After they have that hearing, if they lose, right? Because think about it. If the judge finds that these are official acts, case is dismissed because he has immunity.
Right.
If the court finds that these are not official acts, he's going to appeal. Right. And then we'll be right back where we started. So he's going to appeal. That's going to go up to the circuit court. The circuit is then going to decide it. It then will be appealed up to the Supreme Court if they are not successful. And we'll be right back where we started with the court then now trying to fashion a workable rule, which is some of the language they've used to support this departure from the jurisprudence of stare decisis, right? So some of the language that they've used is that we have to overturn Roe because the rule is unworkable. Well, y'all just made up another unworkable fucking rule.
So if Trump is immune, then Mark Meadows, who was his chief of staff, would be covered anyway, wouldn't he? Because
they didn't say the executive support staff or the executive cabinet was also immune. They didn't say that. They did not say they did not say that.
They didn't say that.
But when we look at this decision, basically the president has unfettered, unchecked pardon power. Right. And so he could get people to do his biddings who might be subject to criminal liability and just pardon them. If they get charged, I'll just pardon you. And it's not reviewable. Not reviewable. So if I'm Biden, the first thing I'm doing is I'm going to pardon my son because fuck all of y'all.
Right, of course.
I'm pardoning my son. I don't even care about what you say. I don't care how it looks. You kiss my ass. Pardon. Pardon.
I
I'm sending them out fast and
right.
furious.
And I don't have a problem with it. You know why? Because that's his. He has the right. He's and all the presidents have done pardons going out the office, and I don't have a problem with that. Now the problem I have is how is this is going to who's going to take advantage of this? Is it going to be Biden right now with a decision, or is Biden going to sit back and wait for Trump to take some kind of well, we know Trump's going to take advantage if he wins.
What is
we know
Biden going to do? What? But he did. He gave a 5-minute little speech, and pretty much just quoted Judge Sotomayor. I don't think that the Democrats have a plan. They haven't had a plan. What's happening right now is the result of the long game. We've been saying that the Republicans are playing chess. I've been saying this for years.
That's right.
For years. And this is now, it's just come to pass. This is the fruition of them playing the long game. They knew what they wanted. They wanted to overturn Roe back when Casey versus Planned Parenthood was decided. They've been biting at the chomp, or what is that expression? Bit at the chomp, yeah, biting at the chomp, whatever it is. Yeah, they've been waiting for an opportunity to do this. The same is true for the Chevron decision. They've been waiting to overrule Chevron, just fucking waiting, and then they got an opportunity to do that. Right?
Let me ask you a question.
We'll talk about Chevron in a second.
Yeah, but let me ask you a question.
Go ahead.
With this, let's assume that Trump is going to win. What type of liability, or forget liability, what kind of risk will those who have been trying to prosecute him, for example, Fonnie Willis,
Alvin Bragg,
who was prosecuting him, Letitia James, I think Cannon is good from Florida, but
she's straight.
Should they be really concerned at this point?
Yes, they absolutely should be concerned, because we are dealing with Donald Trump. He is not a rational person, and he is quite vindictive, right? And what's to stop him from going after them, from launching investigations? And the way that these courts have twisted and contorted facts to fit, their judicial agenda. I'm choosing my words carefully here. It very likely that they could do the same thing with respect to these people, right? What's going to stop him? What's going to stop him?
And he's been hard. Trump has been hard on the media. He's been pretty hard on the media over the years. I'm concerned that now, I'm concerned with even those in the media and what he can, because he can order somebody execute it, and what can anyone do to him?
I really don't think that that's a realistic. But I don't know what's realistic anymore. I feel like I'm in fucking bizarro world. I'm trying to set this up so y'all can see the screen, so they can see the screen on Instagram. I don't know. That shit is trash. That's not very good.
So fine.
Y'all need to see Dennis.
Okay, so Ike, so what Judge McAfee has to do as well is apply
chomping at the bit. Thank you, Mikey. See, that's why I don't like coming on late. I don't have it. Go ahead. Sorry.
Okay. So Scott
McAfee,
Judge Scott McAfee has to apply this similar, I guess, test. For
his case has stayed. He doesn't have to do a goddamn thing. The Supreme Court stayed his case.
Well, the appeals court in Georgia, stayed. Yeah,
they stayed his case, so there are no proceedings in that case.
None. But
none.
Once they make the decision, he still has to deal with this case. Now,
right. Well, they first have to get past the disqualification hearing.
Right.
right? Once that's
Right.
done, then they'll file their motion, just like Trump. Trump just filed a motion in New York County, to
For
dismiss the
what?
counts, to dismiss his state charges based on the Supreme Court's decision
Oh,
in
that's
Trump
I didn't
versus
think about.
U.S. Yes,
Right.
his people just filed a motion. They're like, hey, we're
Okay.
immune. We're immune.
Well, those charges stem from the 2016 before he was even president.
Exactly.
I don't see how he's immune there. I don't think
I don't
that's going to
see it
fly.
either. I
Right.
don't see it either.
That's
And I don't
right.
think Judge Marchand is going to see it either. I think Judge Marchand is going to be like, nice try. Is your client ready for sentencing? Because that's how, on sentencing day, that's pretty much what happens. You go into court, you stand there, the judge is like, okay, people, you ready for sentence? People ready for sentence? Counsel, is your client ready for sentencing? Yes, he is. Only time a defendant is not ready for sentencing is for some reason you need more time, right, before either you go in or sentence is imposed for whatever reason. And you can ask for more time before sentencing, but eventually sentencing is going to happen. And yes, my client is ready for sentencing, and that's when you make your application based on whatever his exposure is, and you ask the court basically to sentence him to the minimum. That's what they're going to do, ask for probation. While the people will likely, who knows what their sentencing request is going to be, it should also be probation, and then the judge will impose sentence.
I think
tell you guys over on Instagram, come over to YouTube or Facebook, because my phone is dying and I cannot get up to find the charger. That's what I was doing.
Okay.
I was looking for the charger, Dennis. So I'm gonna get off of let me hang up off it Instagram. So hold on. Come over there, Facebook, guys, or YouTube. Either or. All right, peace.
Okay,
Ike, about to die. Sorry.
Look into my eyes, Ike. Look into my eyes.
Yes. I'm trying, All right.
Okay. So because you throw me off with that. You throw me off when you did that. So I guess my question is, if I guess my point I want to make is Bragg he might be rethinking his sentencing of Trump now that that this came down.
In what way?
In the way that if he recommends jail time, and I don't see that happening now. I don't.
Yeah. My position is still the same. Bragg has had a policy. I think his recommendation should be consistent with his policy, and that this is a nonviolent offense and he should not be requesting jail time, period. I don't care who the defendant is.
Right.
He shouldn't be requesting jail time for a nonviolent offense. Trust me when I say that if they request jail time for this guy, they're getting your ass too. It's a very slippery slope, right? And so I don't want my clients to show up and on a nonviolent and be subject to jail just because they put this clown in. You know what I mean? That it's not appropriate. It's not appropriate. So probation will probably be his sentence, and I'm sure he'll go through the appeal. He'll go through the whole appeal, the appellate process. He's got a great appeal. He's got a great basis for appeal, and especially with the court's decision in Weinstein. I've said this before, right? The court's decision in Weinstein gives his defense attorneys great precedents, right? Should courts follow their precedent? Great precedents, in having this case overturned. So it's possible, because I don't think they should have had Stormy Daniels testify.
Right, exactly. And I think that prejudiced the jurors, and
they had actually, what I saw? I saw they interviewed some person, a woman, whatever, and she said, they asked her about the trial, and she said, I think he should go to jail because he cheated on his wife with that woman in his wife's, and he took her in his wife's bedroom or something like that, right? Because the testimony of Stormy Daniels was that she had been to his residence and she had been in Melania in the bedroom and all of that, right? And so there are people that are so put off from those allegations that they are not even considering the actual allegations of falsifying business records. And that is the problem. That's why a court could say he didn't have a fair trial, because Stormy Daniels having sex with him was not an element of the crime.
Exactly.
Falsifying business records. You didn't need to prove that he had sex with her in order to establish the falsifying business. You didn't need to do that. And the fact that you did probably was more prejudicial than it was probative.
Probative, exactly.
Yeah.
Well, okay, so we'll just have to see. I think all the cases for the more federal cases, everything's pretty much on hold. I think for the most part, everything's on hold. He'll likely be,
There's going to
he
be
might,
some hearing. Well, he's got, look, sentencing is what, July 11th, July something, the New York sentencing. Judge Chutkin is going to have those hearings. I'm sure there's going to be some hearings, right? When she's going to have them between now and November. What we know is there will be no trials, right? There will be no trials. No trials are going forward. We know that there's no trial in Fulton County. We know that the DC court cannot proceed until they have a hearing consistent with the decision that came down today. So that's not going forward. You know that Judge Eileen Cannon over in Florida is conducting all manner of hearings to try to find out whether or not she can disqualify Jack Smith or his appointment is unconstitutional. I don't even understand that. So yeah, it's a deadlock. He'll be the presidential nominee and, in office if he wins. None of this is going to keep him from office. Do I think Joe Biden can, do an executive order that says, felons can't run for president? I would love to see it. I would love to see them do something like, real.
The legal scholars are contemplating or brainstorming.
Yeah, what's the next move?
What's the next move? Because
what is the next move? Because the moves are limited. It's not like you can expand the court. Everyone's like, expand the court, expand the court. Congress is not going to do that.
Right.
Congress, we have the most ineffective Congress, right? They're so bipartisan and they can't come together to do anything, one. And they'll never come together to do that.
Right.
No.
It definitely ain't happened in 6 months.
And then the other side of that is, so you expand the court and the Democrats lose the election and they put some more conservatives on there. They got a super majority now. That's why that's not the answer to me. That's not the answer. Maybe we explore term limits, right? Maybe we explore term limits. Maybe we explore a judicial code of ethics for the Supreme Court so that we can monitor exactly who is funding, your trips, funding these private vacations and whatnot. We need to be able to look into those things to see if you truly are impartial or if you are beholden to the people who are lining your pockets and paying for your mama's house and paying for is it his nephew or some family member? I think it's his nephew who's going to private school and I think it's Harlan Crow was paying his tuition. That stuff needs to be investigated.
Trump, the president, not just Trump, the president can actually take money to pardon people right now, and he will be he can. It's not against the law. I mean,
yeah, it appears that he has wide latitude in his official acts, right? Because again, what's an official act? If I'm using the office of the presidency to issue a pardon, that's an official act,
right? Now,
if someone pays me $1 million for it, I mean, didn't somebody pay him $1 million anyway? Wasn't there one of the rappers paid him $1 million? Is that true, guys? Let me check the comments.
Let me say this: he has a credit unlimited credit card right now.
Well, he also has a lot of judgments that he has to pay.
Right, you can get out of jail. You can get out of jail. You can get out of jail.
Yeah.
I mean, he's protected. He's protected.
Yeah. Well,
I mean,
he put 3 of those justices on the court.
That's right.
And I'm sure in those conversations, he said to the FBI, was it Mueller that he said, yeah, I just want to make sure that your allegiance is to me. You
Mueller,
know,
yep,
no,
yep.
yeah, no, my allegiance would be to the country, to the United States, to my office. And you know, he didn't stay around. So I don't know if that was the conversation that he had with Amy Coney Barrett before he appointed. Like, listen, I need to know your allegiance is going to be to me. You know, and these jobs are coveted. These are coveted positions, and who's to know that they won't say whatever he wants to hear, right? Just so that they can get the job and then feel like they have to stick to, you know, what it is that they represented that they would do if they did get appointed.
Because they all were handpicked.
Yeah.
For they all were
Yeah.
handpicked.
And you
Uh,
remember I remember the confirmation hearings, right? When all of them had been asked that question about Roe versus Wade. And they all said no, they would not fucking overrule it. They all said it, you lying pieces. They said it. I mean, somebody has got to go get those clips and put them together. Put the clips together of them in their Senate confirmation hearings lying through their teeth saying that they would not overturn Roe. I haven't seen that.
which right. And somebody should do a mashup on that. I agree.
Yeah.
Okay,
Yeah.
moving right along. We have the transcript. We have the transcript here.
Okay, wait, before we get to that, I just want to quickly talk about the Chevron decision because I know a lot of people have been talking about it, and I've been hearing people talk about it, and they have not been
uh, uh,
accurate. They have not been accurate. So just
can we
5
do a special? Okay, all right.
Just a couple minutes. Chevron was a decision because this is important. People need to understand what this means for us as a nation, right? We have all of these regulatory agencies: the FDA, the SEC, the ATF, the water, not the EPA, right? All of these agencies that govern all of these aspects of our lives, right? What we eat, our water, our air, all of that shit, right? And now, so when Congress enacts legislation regarding these agencies, sometimes the legislation isn't so clear, right? It's what we call ambiguous. In the instances when this legislation is ambiguous, a law, a rule, or statute is ambiguous, the courts are supposed to look to the federal agency that is in charge of that area and give them deference on their interpretation of that ambiguity. Okay? Why do they do that? Because the people in these agencies are experts. They're in the best position to know what is intended or what Congress meant by this. Chevron was the case that stood for that principle, that courts must give these federal agencies deference in interpreting these statutes. The Supreme Court reversed 40 years of that precedent. Okay, 40 years of that precedent, and no longer now will courts be required to give federal agencies any deference whatsoever. In fact, these courts now have to supplant their own understandings for that of the experts. That of the experts. So that happened. And so what that means now is that it's going to really hamper the ability of these federal agencies to do their jobs or to do them effectively. We can expound on that a little bit, but I just wanted to make sure, that I spoke on it real quick. Okay. They're all in bed with the corporations that they don't regulate. They don't want regulation. They don't want any regulation. Laissez-faire. Laissez-faire.
Okay, let's move
All
to
right,
this.
let's move to the YSL trial.
Yes,
YSL trial.
yes.
So bigger teams go on the YSL trial. Judge Glanville. Okay, so we got to back up before we talk about what happened today, right? So there had been several motions to recuse. So the motion to recuse is when you ask the judge, say, "Hey, look, you being unfair, motherfucker. I need you to step down." Right? Okay, so they filed these motions, I think, with 4 defense attorneys: Steele, Shard, 2 others. All right, filed motion.
Adams and Weinstein.
Adams would be with Steele, so I don't think he would
Well,
file a separate motion.
he did.
He did? Okay.
Yeah.
All right. So those motions, the judge initially had denied them. Now Weinstein, I think it was Weinstein or Shard, had been making the argument that the court was not entertaining the motion properly, was not
And Matthews, correct? Matthews.
I knew it was someone else. That the court was required to send the motion to a different judge. And initially, Judge Glanville was like, no, I'm gonna do that. These are just assertions. Why he kept saying that, I don't know. These are just assertions, and I don't have to. And so
he did a three-prong test.
Right.
He tested the timing of his filed on time,
right,
the affidavit, and then the
Right.
last one was, did it have any validity?
Right.
Well, he decided that too. No, but
Right.
no, Playboy, you don't decide that one.
Yeah. Yeah.
You
So he denied it. After that, the lawyers brought a writ of mandamus, which means they are going to the Supreme Court to ask them to force him to send this case to another judge. So before the Supreme Court could rule on the writ of mandamus, I haven't seen them rule on that. Judge Glanville did a 180, and he decided to send the case to another judge. So all the proceedings in the YSL trial are now on hold until another judge has an opportunity to render a decision on the 4 defense attorneys who have filed motions to recuse. Now, the other thing I want to say is that this judge, whoever it's going to be, right, because I heard Glanville say it's kind of like what they do here in New York, is a wheel, right? So that there's no, favoritism, there's no forum shopping, no judge shopping. It's random, the selection. You don't know who you're going to get. You don't know who the judge is going to be, right? So they're going to do that. That judge, right, might make this decision. He might say, Judge Glanville, he's doing everything fine because he is the chief judge, right? And what's the likelihood that he might say, and deny their motion? The question then is whether or not that judge would give them a certificate of appealability, right? Because in Georgia, in order for you to have that appealed by or looked at by a higher court, the lower court has to agree to send it up. And Judge Glanville has been denying them this certificate of review. Yeah, of review, right, on every motion.
On everything.
So I'd be really interested to see if the new judge, whoever it is, depending on how he rules, if he rules against the defense, if he would be inclined to grant that certificate of review.
Now here's the thing. In Fulton County, it's a part of the Atlanta circuit. So if each judge say they want to recuse themselves from this case because just think about the high
conflict. Yeah,
it's this conflict, a lot of press coverage. Any judge that rules on this is going to be looked at, especially this is a RICO case.
Right.
They could then go to a different circuit, Cobb County.
Right.
And maybe a judge in Cobb County or DeKalb County can rule
on this. That's always an option. That's always not. If they can't find a judge or a judge is not comfortable or, making the decision, they could send it out. Send it out to another county, to a judge to decide it.
And I spoke to someone that works for one of the judges in that county.
Okay.
And they basically said that it would make sense for all the judges to recuse themselves, but they don't have to. They can also make a ruling on the motion without even having a hearing. They could just read it and say, no.
I thought I heard the defense attorney say that a hearing was required.
Okay, so if it's a hearing, and they also said
but I could be wrong. He could decide it on the papers.
Well, no, the caveat is that if there's something in that motion that requires by state law that they have a hearing, then they can have a hearing. Other than that, because we saw Judge Dempsey last week make a ruling with one of the motions filed by the attorney. He said, well, I read your motion, I made a ruling already. And he said, Judge, I would like to have a hearing on it. He said, well, okay, why would you like to have a hearing on it? So the guy explained why. He said, okay, that now you had your hearing.
Ask and ye shall receive.
He didn't know he didn't know he was having a hearing when the judge started asking questions. He said, okay, now you had your hearing.
Oh shit.
I said, oh my goodness.
Oh, that was it. I thought you was giving him a separate proceeding. Okay.
No, this is the hearing. So
like, I heard you.
What he said,
you were heard.
What would you, so what is it not in your motion that you wanted, you would add it or you would like to argue? And so you start explaining it. He said, okay, I heard it. I disagree. That's your hearing. Moving right along.
It be like that sometimes. Listen, it be just like that sometimes. But yeah.
So did you get a chance to let's bring this up here real quickly. Yeah. Oh my goodness. Here we go. This is do we know if this has been redacted?
It's not redacted.
Oh my goodness. We need still wait a minute. I don't know if that's good enough. I need to hear the audio.
Is there an audio? You have audio?
There was audio.
Oh, I rather hear the audio.
Right. So there was an audio, and there was talk about the audio, but this and the lawyers also said we would like to hear the audio. Not that we don't trust you.
No, I agree. If there's audio, I would want to hear it, but usually there isn't audio because you have a court reporter who's transcribing everything that's said. So
she's recording it, and judge also acknowledged
okay.
Judge also acknowledged that there's audio. So we need to hear the audio as well. We can read this and entertain this, but I think when it comes down to another judge making a ruling on even for Mr. Steele to have to serve 20 days, well, we need to hear the audio because this is a criminal contempt. This is criminal contempt.
I don't think that. I think that's going to go away, just like the whole order to show cause that had Bumpus and all the other 10 or 11 people that were in the room summoned to court so he could find out who told. He canceled that too.
He canceled that.
He canceled that. He made a big deal about it, and then he canceled the whole thing.
So why do you, before we go into this track, why do you think he just did a 360 degree, 180? Why do you think he did a 180?
Because they filed a writ of mandamus.
And but the court also said that they dismissed it, but they also had some guidance.
The mandamus was dismissed?
It was dismissed.
And what did he say? What was the guidance?
I don't
have. Is that
the
one you're saying, Dempsey?
No.
Okay.
No, but they dismissed it, but they had guidance for the judge, for the Superior Court judge. So I guess he told
hearings. I thought they said
no. So what the guidance essentially said was that the judge should have sentenced to another court. That was the guidance. So
there you go. So that's why he did a 180.
Yeah, because now the Supreme Court.
Because even it was either one or the other thing. He wouldn't have done it if he wasn't pressured to do it.
Absolutely,
he was not going to do it. So they had to file that writ. They had to get the Supreme Court. They had to jump up and down, say, "Hey, look what's going on over here." Have the Supreme Court say something to him so that he, would have some sort of, check on his behavior.
Right. Absolutely.
So he finally did the right thing. Finally.
Well, let's just see. I don't know about these judges, and if it stays in Fulton County, I would be a bit concerned in light of the fact that he's been one of the judges who's been around for a long time, and they have respect for him.
Chief judge. He's the chief judge.
Right.
So you think about what happens if you rule against the chief judge. I guess you're gonna be doing night court. You come get the shit detailed. Yeah, we're gonna need you to come in on Sunday. That's some bullshit. Like, I don't know. I don't know what the ramifications are, for that. Like, I don't, but it seems like Fulton County, from all appearances, it's very catty, very networky, very clicky, and if you are outside of the clique,
that's right.
You might, I don't know. So nobody wants to be outside the clique. So I don't know if if they get a Fulton County judge, he's going to feel like, hey, I got to get along. I got to go along and get along, And that's
So
the fear there. That's the fear. What?
I'm laughing at Rose says she Rose. I ain't gonna repeat. Rose.
Right.
That was funny, Rose.
Well, do you know what, Rose? Who was it? Who was it today? AOC. AOC tweeted that when she comes back from vacation, she gonna get those articles impeachment together.
For the justices.
I don't know
Oh
which one, but I'm gonna guess it's Thomas and Alito.
Oh my goodness.
Right, because a lot of people. Oh, let me just correct something. Yesterday at the BET Awards, which was trash. Taraji P. Henson. I know you want to listen, sis. Call me before they give you the talking points, so you don't sound crazy. You on there talking about we got 3 Supreme Court justice seats up for we do not.
No, we don't. We do not. We do not.
Like,
what
and this is me. I'm like, what the fuck?
Taraji, what are you talking about?
What are you talking about? You on national TV espousing nonsense. We don't need misinformation. Right. We don't need any more disinformation. Right. We have had enough of that. The reality of it is we may not be getting any Supreme Court seating, right? Because we really, really want to look at the Supreme Court. Think about this for a second. In order for us to make a determination as to when a judge might retire, we should look at when judges have retired in the past, right? That would make sense. So let's see. Stephen Breyer was the one who retired most recently. How old was he? That's the one who Ketanji Brown Jackson got his seat.
That's right.
He was 83.
That's right.
83. All right. Let's talk about Ruth Bader Ginsburg. She didn't retire. She died. 87. Clarence Thomas is 76. Why would he retire? He's 76. Alito 75. And the next judge, I think, is Sotomayor, who's like 69, 70. Roberts is like 69, 70. Mm-hmm. Ketanji Brown is like 53.
That's right.
Coney Barrett is like 53, 52, 53, 54. They're young.
And Judge Kagan?
Kagan is like 60. Hold on, 66. I want to say 67. She's around there. Hold on, let me see if I have it written down anywhere.
I think the two younger. I think it is Kagan and
Kagan is 63, 63,
yeah, right,
64.
Right. Kagan and
Gorsuch is 56, 57.
Okay.
Right. Barrett is 52, 53. Sotomayor is 70. Alito 74. Thomas is 76. So
and Kavanaugh.
Kavanaugh is 50, 59.
Okay.
Can't read my own handwriting. He's in his late 50s. Put it like that. So he's not going anywhere. These are lifetime appointments.
Right.
Right. And so if Biden wins, why would they retire? They would definitely be like, well, I got to sit here for 4 more years because I'm not about to give up this seat to a Democrat or a liberal.
It's not happening. It don't happen that way.
Happen. Now, if Trump wins, they mean like, hey, it's time to retire because they want to make sure that they put somebody young in those
absolutely.
Seats, right?
Absolutely.
Who's going to be there for another 20, 30, 40 years. That's why maybe it's time for us to visit term limits.
Right. And Thomas probably be one of the ones that go out. He'll probably be one. I think Thomas and
I swear I feel like he's the last person who would what else is he going to do? This is his entire existence. Just, you know what I mean? Like, I don't see him night court in Alaska on Sunday. Right, Mikey? I don't see him saying, I'm going to retire. No, this is the only reason why people speak to you. I'm sorry, Clarence. I know the truth hurts. But if you weren't the Supreme Court justice, why would they fuck with you?
Right.
They wouldn't. And he knows it because they ain't fuck with him before he was the Supreme Court judge.
Because he was the EEOC commissioner, right?
I don't know what he was.
Yeah. I believe he was EEOC before he came in.
He was PP in my Coke. What you do? You got pubic hairs in my Pepsi.
Right.
Pubic hair in my Coke. I'll never forgive you for Anita Hill.
Right.
What you did to Anita Hill.
Right.
But
so let's go
he's
with
not
this.
retiring. So that's my point. It's there might not be any Supreme Court seats up for grab.
Yeah. So Taraji,
And that's the only way. The only way we could do that if Biden wins and then they expand the court to guarantee that those seats are going to be liberal Democrats. That's the only way.
do you see the court being expanded? Do you see that? Yeah, I don't think
see
so.
it. I don't see it. The court has been 9 justices since post Civil War, sometime around there.
Right.
I mean, there was a time where I think we had as little as 5, but that was in the early parts of our country. It's everything was new and it was just starting. So, eventually they worked up to 9, and this is what it's been for. I don't even know what year. I can't even say, but it's been this way for years. Okay, but listen, they overturning precedent, so shit. I say, the fact that it's been this way doesn't always have to be that it needs to stay this way.
Okay,
I just don't think that's the answer. Okay,
you want me to start? Do you want me to start reading this when we start out?
Oh yeah, okay. So this is the transcript from the secret proceeding that Judge Glanville had ex parte. Ex parte means he only had one side of the controversy present, meaning in this people versus people of the state of Fulton County or Georgia or whatever it is versus these defendants. He only had one side of the verses. Okay, in the ex parte. So in this one, he had this is the one where what's this guy's name again? Copeland, but what's his
Copeland? Kenneth Copeland.
What they call him? Lil Woody. Lil Woody. With his attorney, the judge, the prosecutors, some security personnel. I don't know how many people went in there, but all of those things are factors as well. When someone is sitting in a room and they are surrounded by authority figures, the setting alone could be pressure filled.
Absolutely.
You liken it to an interrogation in a police station where the police officers, are sitting in front of you and they keep playing with their guns and they're asking you questions and
the hot lamp.
Right. So, who's around could be a factor. All right, so let's get into it.
Okay, so the ex parte hearing began at 9:10 a.m. Present in the chambers were Judge Glanville, Assistant District Attorney Adrian Love, and Attorney Kayla Bumpus, court reporter Christine Weaver, and investigators Antonio Long and Rashid Hamilton. The court reporter. Okay, I'm ready whenever you are. Miss Love, thank you. The concern that we wanted to bring to the court's attention as the state was twofold. One, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. The second concern that I have is, and I wanted to bring to the court's attention in line with the concern that I expressed on the record on Friday. I don't know what advice counsel may have offered or may be offering that is their right and their business. But you just see the tonage that she's using as it relates to
just like she does in court.
Exactly. As it relates to testifying, however, I do not believe that criminal exposure is a concern that is which interest is being spoken about and protected. Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of the statute 24-5-507, and on Friday he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Sharp. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele and to Mr. Sharp with me and Simone copied where he said, "This is the communication that I received from Ms. Love regarding Mr. Copeland." My response was, Whose interests are you protecting, yours or Mr. Steele's? Which client are you protecting? Whose client, yours or Mr. Steele's? And Mr. Shorts, and Mr. Shorts. He wrote back and said, "You are going to get him killed. You have made him, you are making him a target. Fuck you," is what he wrote in the email. Damn.
Let me pick it up. Let me pick it up. So, given that his concerns and that by testifying, at least the one that he conveyed, I don't sure. Can you make it bigger? At least the one that he conveyed to me in writing, it's not, his concern has nothing to do with exposure from the state. And if his concern, the court, his being whom, his being whose concern, Miss Love, Mr. Melnick, if the interest, you looking to see if you can make it bigger?
I don't know how to make this thing bigger.
Yeah, it should be like a plus above it. If the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what happened. I'm sorry, what exposure does he face? I don't have my glasses, y'all, in testifying. In fact, if he's concerned in testifying, we'll get him killed, and he is not communicating with us, he's communicating with counsel for defendant. It would seem that he knows a thing or something that we don't know. Additionally, and I will let Miss Bumpus tell you, he...
Okay, let's switch. I'll change the page. Here I go. Go ahead.
Yeah, no, ain't no bigger. He has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem you would want to be there for him while he is testifying. The court, well, he is on vacation this week. Miss Love, I understand. That is why he has Miss Bumpus here, and he has said what he has said. Shut up. And as I was reading, the statute, the thing is, and I was reading the statute about this particular situation, and I don't like people who use too many words. And I was reading the statute about this particular situation, and I was reading the rules, our ethical rules of conduct for attorneys, and it is clear that if an attorney, there were two things that were happening. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland had told Miss Hilton that Mr. Melnick wasn't representing him. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Sharp. And Mr. Melnick reaches out to Mr. Copeland and injects himself into these proceedings. What we were discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on. And that is where we are not allowed to speak with a person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about because we were talking about this case and...
Hold on. Here we go.
This trial. All that aside, we would like the opportunity for the court to address Mr. Copeland, and with Mr. Copeland's standing counsel present, Ms. Bumpus is looking at me like... Miss Bumpus says, I'm listening. Miss Love, can you imagine that? Like you standing there listening to this chick say her bullshit, and then she got the nerve to, well, you looking at me like, I'm looking at you like what?
Right. What?
Like what? You about to characterize my face? This is my resting bitch face. This is my resting bitch face. Oh God, Miss Bumpus is like, I'm listening. Right. I'm like, what is your problem?
What's right? Just get to the point, right?
With his standing counsel present and to allow Miss Bumpus an opportunity to explain to Mr. Copeland everything that I have just said. Her concern outside was what is the longest he can stay in jail. What I relayed to her is the statute says until he purges. The court by testifying. Miss Love. His contempt by testifying. The court, 50?
507 is
507 is a little bit
different.
Okay, so I mean, Miss Bumpus, so until the end of this, the court, he can be here until the end of the trial. Miss Bumpus, that is what I said. To the end of the trial is the longest? Miss Love, no, it's not the longest. even after a grand jury. If a person has been subpoenaed to testify before the grand jury, and even after the grand jury has what it is convened, has left, that person can stay in until that person purges himself of contempt by, I'm guessing, testifying. That does not. Why is she comparing his testimony at a trial to someone testifying in a grand jury?
Right. It is different.
It's wholly different.
Totally different. And they're not going to ask as
because how
detailed.
do you purge? So how do you? This is stupid. How do you purge once the trial is over? By testifying. You gonna testify in a trial that's over? How does that work? Exactly. How exactly does that work? So I got to sit in jail. That you can't do that indefinitely, in perpetuity. That makes no sense to me. That makes absolutely no sense. Miss Love.
So the statute literally says that. Okay, Miss Bumpers.
Okay, go ahead.
Miss Bumpers. Well, I'm going to look it up because it was my understanding that it was until the end of trial. Miss Love, nope. Here it is. Literally the words of the statute. And so the court, he could be in there a while. Let's put it that way. Either way, come on, Judge. What are you doing?
You're just co-signing what she said, which was just, and what she said made no sense.
Right, Judge. What are you doing? Just let her explain. You're basically another prosecutor in the room. Ms. Bumpers, I just want to be able to give him the court. I know. It's kind of the statute says, that you purge, but I can't keep him in there indefinitely. I've got to kind of Ms. Bumpers, right. That is all I want to know. The court, the whole thing is that he has the keys to his own freedom. Oh shit. And that freedom is if he just gives his testimony, then he can purge it. Ms. Bumpers, right. Miss Love. And whatever that testimony is, we know what he believed it to be. We know what we believe it to be, but we don't know what it is. We can't talk about it. We don't, we don't know what he's going to say. We have an idea. We know what he's told us.
I don't understand that, but wait, stop. She's saying, okay, and
it's kind of
testimony is, what we believe it to be, but we don't know what it is. How do you not know what it is? In the very last sentence, you say, we know what he's told us.
So she's saying that we know what he said in the past, but we don't know what he's going to say on that stand.
Yeah, but you know what he's told you.
Okay, but
all right,
that saying in front of that jury may be something different, as we can see with other witnesses got been testifying. Miss Love, and whatever that testimony is, we know what. Oh, we got past that. Okay.
Yeah.
Okay, Miss Bumpers, yeah, Miss Love, and our concern is that I know the court said essentially you intimated. You intimated that Mr. Melnick probably told him essentially, let me go to the next page. You should testify. They can't do anything with your testimony. But what we overheard being said was they are going to hammer you as if we were going to expose Kenneth Copeland to Ms. Bumpers. You heard that?
Yeah, you was ear hustling somewhere.
Right,
what do you mean you heard that?
Right. Who heard that? The investigator. We'll find out. Miss Love, yes, yeah. Mr. Melnick told Mr. Copeland, we're going to hammer him. So, okay, we'll talk about that in a minute. The court. Now, to be fair, and I think Ms. Bumpers, as an advocate, or anybody has got to tell him he's going to face some pretty significant cross-examination. Ms. Bumpers, yeah, I think that's what he meant. The court. I mean, he's going to face he's got about 10, Miss Love. So he meant the defense is going to hammer him. No, the prosecution's going to hammer him, not the defense. That's my part. Miss Bumpers, no, just in the general, he's going to be. It's not going to be a hey da 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 da. Miss Love, he knew that he had already been expressing that the court. But I mean, I think that if he's concerned about that, well, but it's all in the message and the packaging in terms of I think Mr. Copeland is, a savvy person, but he's certainly going to be subject to a thorough and I guess thorough rigorous
cross-examination.
Right. That's what I'm just getting. A thorough and sifting cross-examination, Miss Love. And the other thing is that, Miss Bumpers, can I just say something in Attorney Mellick's defense in response, just for the record? Miss Love, yes, Miss Bumpers. The reason that he doesn't want to move forward with representation, what I have been told, if he decides to testify, is that he doesn't feel like he can. He doesn't know what was said outside of his presence. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there, Miss Love. But the thing is that the only thing that he should be concerned about is the criminal exposure or the exposure that Kenneth Copeland has criminally, and there is nothing. There is literally nothing. The state is quite clear that we can do to him about the only thing that would put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by a lie.
That's not her call. That's the problem. That's not her call. And
right.
She can't appreciate what other issues he might be facing. She can't. She can't say that the only thing he should be concerned with. That's not your providence.
Right. That's what his lawyer can advise him on.
Yeah, you can't tell him. He could be concerned about all manner of shit.
Right. Exactly. Some they know, some they may not know. Right. So that's why he needs counsel. And by lie, we don't mean like, oh, I think you lying. It would have to be, something obvious, because we can't always impeach. But if he literally perjured himself, that's something different. We can't help that. We can't control that. We would only say, tell the truth. I don't care how bad it is. Just tell the truth. So, like he says, I didn't go down to the police station, the court. And I think part of his challenge, Ms. Bumpers, may be that you need to assure him, look, I'm going to be here. And if you think that they are asking you a question, they being the state or the defense asking you a question that's going to bring out other crimes that he's going to be able to look to you and say, can I have a chance to talk with you? Miss Love, that's exactly right. Miss Bumpers, okay. Okay. Now he said, okay. Miss Love, see, but that's just it. Miss Bumpers, no, he's not. Miss Love, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you, Miss Bumpers. Yeah, Miss Love, there's been an assertion that the people are representing his, that their biggest concern is his best interest, and then they are just not here. And Miss Bumpers is saying she's not in a position to do that.
This is so painful. Yeah, I'll take the next one. All right, Miss Bumpers. No, I'm not saying I'm not in a position. I'm saying that the agreement between Mr. Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign his paper that says that he discharged Mr. Melnick as his rep. That's their agreement. I can't do nothing about that, Miss Love. That sounds weird. That does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I can't. I ain't going to. I'm not going to represent you. I don't even know what to do with that, Miss Bumpus. Well, he said he's done. No, he said he does not know what was said, Miss Love. It doesn't matter what was said, Miss Bumpus. Right. So she's still standing wallflower. Miss Love, like, well, it does matter what he said. It does matter. Like, he doesn't want to suborn perjury like you're doing.
Right.
He doesn't want to do that.
Right.
Miss Love, it doesn't she said it doesn't matter what he said, right. It doesn't matter. And he didn't ask us. He didn't even inquire. What have you all talked about? What he has been talking to Brian Steele and Max Sharp. That's it. He's not talking to us. Wham, 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 like a baby. He is not. And in fact, when Mr. Copeland asked to speak with us, Mr. Melnick barges in and gets between Miss Hilton and Mr. Copeland, literally keeps us from talking to him before he gets called to the stand, and that's troubling.
Miss Bumpers. Well, I think
that's not troubling. His lawyer doesn't want his client to talk to prosecutors.
Right, exactly. He should have ran in. What the hell are you talking to my guy for?
You shouldn't have been talking to him without his counsel present. Right. I'd have ran in there and bust up the place. Come on, Miss Bumpers. Well, I think what happened was, and I say this because I previously represented Mr. Copeland. Previously on his other stuff. So I know when this is just what I think happened. I think how Attorney Melnick became involved was his representation of others because he took my place. Copeland fired me and hired Melnick. And then this came about. And I think that's crazy. I think so. At the beginning, Melnick was representing him, and then Miss Love. So he fired you, and here you are again. I mean, can you imagine that? If you
what the hell was going on there?
Come on, if you're the client, right, and you're jammed up in this situation, and the lawyer that you fired shows up, come on, how you gonna be feeling? You're gonna be like, this can't be life,
right? I just got rid of life. Why did she go back over here?
Why are you here? Why are you here? Oh my God. Okay, Miss Love. In his criminal matter that he had, but that's resolved, Miss Bumpus. But when this I can't see that.
But when this case started,
Melnick called me and told me he was representing him as a witness at the beginning. I can assert that, Miss Love. Melnick has never in life. She's about to make a whole ass. She one of those people that argue, you never did this. I always did this. They use those absolute terms.
Right. In life.
Run away from people like that.
Right.
They're emotional terrorists. Right. Because she's about to say something that's just all the way hyperbolic. All right, Miss Bumpus. This is 2 years ago, Miss Love. Melnick didn't. As a matter of fact, less than 2 years ago, when Copeland was sitting in jail for something else he had done, Melnick said, I don't represent him. He told me, I don't represent him. And people were in the room. We were on speaker. He told me he didn't represent him. Like, who is she trying to convince? She said that 3 times.
Right, the judge.
Yes, exactly. He told me, so just believe me. Now he ultimately did come about and represent him. But when we were trying to get, I guess, Miss Bumpus, something? Yeah, Miss Love. Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then, Miss Bumpus, are you talking about recently, Miss Love? So recently, Copeland said that Melnick was not his lawyer. Is that so or no? So,
yeah.
Miss Bumpus, right. Miss Love. When Copeland was in jail, Melnick told me he wasn't his lawyer. Oh my God. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued, or at least stood in for him on his bond and then on his subsequent plea, was Melnick. But I don't know whose interests he should be representing when he's not talking to us about what we've spoken to Copeland about. He could ask us and we could tell him, you know? So I don't know why he would withdraw his representation of him. If his interest is Kenneth Copeland, then why would you pull out? The court. That doesn't make sense. Miss Love. At the point where we would face the most peril, is that his concern? Is if his concern is I don't know what they are talking about and I don't know what, the court. And I thought Miss Hilton had a list of questions for Mr. Copeland anyway. Miss Love, she did. The court. Well, how come you all can't? Miss Love, he didn't ask to see those. We didn't. And not only that, the court. Well, can't you all share that with Miss Bumpus? Miss Love. Well, Miss Hilton has already shared it with Mr. Copeland, and we certainly will share it. Generally speaking.
So that don't
what does
sound
that mean?
right.
We're going to share it generally speaking.
Right. You have a lawyer in the room right now. Let her see the questions that Miss Hilton has. What is this dancing around for?
What is generally speaking?
Yeah,
show it generally. Can you show it specifically?
Right.
Like, Miss Bumpus, can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. It says, "Hey Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight, but I have talked to his family. So at first Kenneth was going to testify, but he now decides to take the fifth. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. And then he gave me the discharge and told me that if he decides to testify, then he's to sign this, Miss Love." And that's just it. It's like you never know what somebody's going to ask. And if he's concerned about putting him in legal jeopardy, then it would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned that he's about to walk into an area that puts him in legal jeopardy. Miss Bumpus, you can't switch how he gets called. Miss Love, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch in how he gets called, what does that have to do with anything? Miss Bumpus, I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. Miss Love, that is not what he said in that email to you, and that is not what he relayed to the court. And his concerns have nothing to do with the court. He was very much, Miss Bumpus, I tried to go back and watch as much as I could, the court. Telling me what, go ahead, you can pick up.
Okay, the court telling me that he was going on vacation, because I was in the court when you said that.
Yeah,
and I said,
I saw the video.
And I said, well, you inserted yourself in this. I said, really? You need to come on Monday, Miss Love. So he can't force Mr. Copeland to discharge him just because Mr. Copeland decides to testify. The court, I think you are in until it's done. I mean, Miss Bumpus, who, me? I'm just standing the court. Yeah, I mean, that's just, if he testifies, you got to kind of, Ms. Love, and frankly, Your Honor, I know that if a person faces criminal contempt, they are entitled to representation if they want it. This being a civil contempt matter, the court, not necessarily anybody who's facing contempt can get counsel. I mean, not anybody, but yeah, like not Mr. Steele. Hey Ashley, where you at, Miss Murphy? Where you at?
Right.
Miss Bumpers, I can't stay. How long is this going to take? Miss Love, it might take some days. Miss Bumpers,
weeks. She said weeks.
Yeah, She said days.
Uh-huh.
It might take some days, all weeks. Miss Bumpers, Miss Love, and see, that's just it. And I don't mean I think Miss Bumpers is put in a precarious position. She's not the one that stood up and injected herself into this. They reached out to her, and she did him a favor. But ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that is a problem because that has nothing to do with the best interest of Kenneth Copeland. And yeah, you care about him really. Yeah, okay.
Right.
And that has nothing to do with Kenneth Copeland's exposure if he testifies. Just to answer the question about he is exposed to, the statute is very, very clear. It literally says that no testimony or any evidence required under the court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he testified or produces evidence under the court's order.
That's transactional immunity, guys.
Transactional immunity, right?
Mm-hmm.
That is saying, even if he got on the stand and said, the court, he started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about is that, yeah, there's a lot of stuff they could ask
You went
me
out,
about.
Dennis.
Can you hear me? Hello? Hello? Hello?
Yeah, we lost you for a second.
Am I back?
Yes.
Okay. Let's see. That is saying, even if he got on the stand and said, the court, he started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about is that, yeah, there's a lot of stuff they could ask me about. Miss Love, right. The court, that is not known to a lot of people, and that, he could also invoke his Fifth Amendment with the advice of counsel if it was some other particular crime. But Miss Love, but even that, we wouldn't even the court, even that he'll still have to testify. Miss Love, literally right. The sore lays. The sore lays. What the hell that mean? Okay.
Where you at? What line?
20.
Line 20, Miss Love. But even that, we wouldn't even the court. Even that, he still have to testify himself. Literally, right. The sore lays. I don't know what she was about to say.
Right, exactly.
Yeah, I mean anything he testifies to. Yeah, we do this.
That's Miss
okay,
Love.
and then about delay or stall. Isn't it true? Or is it not true that he had a leave?
Okay, hold on 1 second. Let me get there.
Is it true or is it not true? Oh God, why do you speak like that? Filed since December. Now, is there a point where they start talking to him?
Well, we didn't get there. What page are we on now? I don't see we didn't get there.
Yeah, I'm looking. This is only page 18.
And how many pages do we have? 30 what?
56.
Ooh, okay.
Exactly.
Okay.
We ain't gonna make it through all of that. It's already 12:15.
Okay. All right. Let me just continue on to at least I'll read about 3 more pages. Cool.
All right, go ahead.
Okay, Miss Love. We have nothing to do with any of that. He injected himself into this. The court. Yeah. See, the problem is, Miss Love, he stepped in. The court. That's when you get involved. I don't know you have a leave. Miss Love, right. You, the court, and unless you file that leave into the case, you don't have a leave for my case. Miss Love, right. Miss Bumpers, okay. Miss Love, and he did not, the court. So he didn't have one. Miss Love, Mr. Copeland's been a witness and a name on this witness list since, the court. So since he said, well, I represent him, I'm like, okay, well, you don't have a leave that's filled in our case. So filed in our case. So you don't went on vacation and didn't even have a filed a
All
leave.
right.
He's going to be held in contempt
You
too. Miss Bumpers.
have to
Okay,
write a
okay.
letter.
Right. Miss Love. So he did this to himself and he did it to you. But we have to, that is just where it is. And I don't know that. That's just where we are, Miss Bumpers. So, Judge, you are going to make me stay if he chooses to testify?
Yeah, yes, you on the hook.
The court, I am because he's your I am because you're his lawyer. You're his lawyer. You are a stand-in lawyer at this point. Ms. Bumpers, Your Honor, I don't have a problem with that. I'm not ready, Ms. Love. If the court, there's nothing for you to be ready about. I mean, here's the thing. I think that the only thing you've got to kind of ask him about is, is look, here is the questions the state is going to ask you. All right, is there anything else that could hurt you that they might ask you about? And as long as you have knowledge of that, then I think that you are fine because the state's only going to get into this. Now, the reason you want to know what's going to hurt you is the defendants know more about Kenneth Copeland than anybody else. So they are probably going to kind of, Miss Bumpers, what about if I say I can't do it? Then Melanick needs to come back, right? She trying to get the hell out of this. She'd have said that on the lead attorney.
Right. No.
The transcript. Listen,
then, right.
Listen. Transcript can work both ways now.
Right.
Exposes everybody. Am I going to be Am I going to be in trouble, girl? What are you talking about? You don't want to be with him. That's why. Listen, that's why he fired you in the first place.
Exactly. You don't have no gumption, no backbone, no pushback, no nothing. Just go along and get along. Absolute potted plant.
Because I was only for Monday.
I'm only in for one day.
Right. That's what I was told. I was given specific. Miss Love, if Copeland said, I don't know what Mr. Copeland wants, it's his choice. Miss Bumpers, can't he say he doesn't want Melnick? Miss Love, he can say whatever he wants. It's his choice. Miss Bumpers, you really trying to get out of here? Kind of hilarious, actually. Miss Bumpers, but the judge is saying, Miss Love, I don't think he can be forced to have representation if he doesn't want, need, or say he wants it, because we have offered, we have done everything to clear him of judicial exposure. He's not, there is nothing he can say he could lie. That puts him in, the court peril. Miss Love, peril. So you're both chiming. Okay, but he can't talk about a crime that we could then prosecute him for. The court that is involving this or some other place. Miss Love, right? Miss Bumpers, I understand that, but I still want to get the hell up out of here. Miss Love, and we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Now, Ike, how comfortable are you when a prosecutor says something like that? You don't think they're going to investigate something if he says something, slips and says something?
If he has immunity, it doesn't matter what he say. They can't prosecute him for anything he says and go investigate and come up with stuff. They're really not supposed to be doing. The only thing he's subject to is perjury.
So basically, he's literally shielded. Ms. Bumpers, I would have to agree with you that I don't think that that's the concern. Isn't that what you said, Ms. Love? Well, the court said that. Ms. Bumpers, no, I'm saying with Mr. Copeland not testifying, you said you don't think that his concern is criminal exposure, or you do think that it is that what he's worried about. Well, damn, you're the attorney. You need to talk to your client. Don't rely on the prosecution to tell you.
Right.
That's what the hell they doing here. The
I'm looking.
court. Do you think that he's is fearful of testifying for the other reason, like for his personal safety? Miss Bump is right. Miss Love. That is what Mr. Melton said to me in a email I can't pull up. He said, Miss Bumpers, but you don't believe that, Miss Love. You are going to get him killed. That's what he said. We ain't going to kill him. Miss Bumpers, see, I don't know anything about that email. Miss Love, I said, Miss Love, we ain't going to kill him. I can show you the email, but we're not going to kill Kenneth Copeland. So who is he talking about? So what are you trying to do? The court. That is a collateral second and third order effect. Let's pray it doesn't happen. But Miss Love, I mean, obviously the court, first he has to give testimony though. I mean, that's what he has to do. He's got to give the testimony, whatever it is, good, bad, or indifferent. Good, bad, or indifferent, I should say. Okay. Miss Love, so we would like, with the court's permission, they haven't brought him over, and he wasn't there yet. That's why he probably said it. And we was supposed to be the first one up. So I guess they went to get him. They might be over here with him now. Okay. That's why you asked that question, Ike.
He's in here. He starts around. Let me tell you what page. Page 23.
Okay, let me. Oh, that we just getting up on there too. Okay, so that's I'm 22 now.
Okay.
Let me finish 22. The court, is he here now, Ms. Love? I don't know. Judge Glanville exit chambers at 9:33 a.m. Ms. Love, we would like to just go into another courtroom and talk to him, give you a chance to talk to him, and then give you an opportunity to explain to him, the court reporter. We're off the record. Okay, court. Okay, brief recess. Judge Glanville and Mr. Chamberlain entered chambers at 9:34 a.m. Miss Love, Miss Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. The court. Where's Mr. Copeland? Mr. Chamberlain. They took him upstairs to the tank in 9. So they got him in the holding cell. The court. Okay, can we bring him out? Can we? Mr. Chamberlain, your chambers is being used. I mean, your courtroom is being used. The court. Let's bring him in here. Mr. Chamberlain. All right, so let me see if I can get that done. The court. Let's bring him in here. Okay, thank you. Well, we'll just bring him here. Okay, this is 23. You ready?
Yeah. Mr. Copeland, that part where you entered chambers at 10. That's what you're up to?
Yep.
Okay. Entered chambers at 10:03 a.m. Also present were Judge Glanville, Assistant District Attorney Simone Hilton, and Attorney Caleb Bumpus, Court Reporter Christine Weaver, investigators Antonio Long and Rasheed Hamilton, and Deputy Houston, Deputy McPherson, Sergeant Brown, and Sergeant Hall with the Fulton County Sheriff's Department. The court. Okay. Mr. Copeland, can you let him know?
Well, hold on before you go any further. So you have 4 deputies there. You have 2 investigators. That's a lot of pressure.
2 prosecutors.
Right. What the hell
and
going
the
on
judge.
Here? With no defense attorneys.
Your only ally. No, is Miss Bumpus. She's there.
Well, no defense from the defense team. Like, for Steele, Adams, none of them.
Oh, yeah, none of them. No, none of them. Okay. Copeland says, can you let him know I got a hearing problem, Miss Bumpus? Okay. He said, he's hard of hearing. The court. That makes 2 of us. I've got a hearing aid that's coming on the 27th of January. I mean, of June. So I'll try to talk loud. Is it okay if I can read lips. Of course. Okay. Good. Mr. Copeland. Good morning. Mr. Copeland. Good morning. The court. All right. I just wanted to bring you over and that you talk with Miss Bumpus and see if there's anything that you need to ask of your counsel or Miss Hilton or the state or the court before we bring you out.
This.
Okay. Before we bring you out this morning, because we would like to hear your testimony. And that is kind of where we are at this point in time. So is there anything you want to ask, Mr. Copeland? Well, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. The court. Okay. Well, the only thing you can give is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it, Miss Hilton. And what we'll say, and Mr. Copeland and I, we have talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up for anything, you can't. Like, there's nothing that can happen. The feds, Miss Bumpus. Well, that's not Miss Hilton. It is true. Miss Bumpus, no. I said that's not his concern. Miss Hilton, if his concern is safety, we need to know that. Like, that's not expressed, so we don't know what the concern is, so that we can try to resolve the concern. This is what I'm saying. Mr. Copeland and I have had an investigation before. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations, done. The state statute of limitations, done. So there is nothing. Like, I researched it this weekend again. Both those statutes of limitations for what you and I talked about, which is in 2015 or before, are done. You cannot be prosecuted for anything you testify federally or statewide. Immune, period. They cannot give him immunity from federal crimes. She's fucking lying. She can't speak for the feds.
Right,
she has no authority to say what the feds can, will, won't do.
That right there in the defense, if the defense was in there, they would challenge that right there.
Yeah, they would, because Bumpus is sitting there like dun.
Right.
So if that is the concern, there is none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been in 2020. But if the feds bring a fucking RICO, they can reach back into 2015, just like y'all did.
Exactly. She didn't tell them that.
Duh. So anything in 2015, 5 years, you have been in 2020. Anything statewide is 4 years. It would have been 2019, finished. Next concern, what may happen in the streets? You know what we have talked about, what we can do as far as living and all of that. We have had those conversations. So I'm trying to express to you, we do not want you locked up. I don't know how many times I've got to tell you that. What I've got to say to you, we do not want you sitting in DeKalb or wherever they got you because of this. I know you wanted to talk to me on Friday before you walked into court. You weren't able to talk. If you still want to talk with or without Miss Bumpus, I'm here. But what? Yeah, but we do not want you in custody. You will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution. Any of it, literally. Judge, you might want to close your ears. If you confess to a murder on the stand, if you don't have any other independent evidence outside of what you say on the stand, you're immune from prosecution from what you say in court. So what if you do have independent evidence? You're not immune then? Like, they so stupid. So again, I don't know what the communication to you what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Ms. Bumpus, as I told you, this is what this order says, the court. And that is direct or cross-examination, Ms. Hilton. And that is direct or cross-examination. I don't know what that means. So if you are worried about what the defendants may ask you, because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of these, Mr. Copeland. I got family members watching this trial, and I don't want my nephew and them to hear the things that I may be involved in and think it's okay. Ms. Hilton. But I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I've lived the life.
Mhm.
All my life I had to fight. Yeah, look, nephews, I done lived the life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because that's a better conversation you can have with your nephew in person. But they shouldn't have to come to the DeKalb County Jail because you are being held in contempt. You can have that conversation with your nephews tomorrow in person. Oh, now we're going to dangle some freedom in front of you. You can have that conversation with them. You can have that conversation with anybody. You know what's coming up this weekend? Why are we in jail? What are we doing, Mr.
Right.
Copeland? But y'all did this intentionally,
Right.
Miss Hilton. No, we
No,
did
we did
not.
not.
You and I
Yeah.
had this conversation, Mr. Copeland, on Friday morning, Mr. Copeland. You know my child's birthday was next week,
Ooh.
Miss Hilton. But what did I tell you? When we met with each other, I said to you, why can't she just say when we met?
Mm-hmm.
Right? Why you gotta add each other? Like,
Right.
it's so
Right.
fucking redundant. I'm
Right.
sorry. This the writer professor in me is just I cringe. Okay, Miss Hilton. But what did I tell you when we met with each other? I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And that was my response. If you plead the fifth, and that is exactly what you did on the stand, Mr. Copeland. But what did I tell you before I got to that point? I told you the whole time Tuesday, Wednesday, Thursday, Miss Hilton. But I told you we were giving you immunity.
Well, hold on. They knew that he was going to plead the fifth, and they put
Yep.
him on the stand anyway in
And
front
they
of that
put him
jury.
on the stand anyway.
Now that's some bull crap right
That
there.
is some bullshit. But I told you we were giving you immunity, Mr. Copeland. That I was pleading the fifth. No, you did not. I told you every day I was pleading the fifth. No, you did not.
Bust her down.
When we told you, Mr. Copeland, I told you my concerns, Ms. Hilton, and we said we could give you immunity. You said your concern is that they know about you. And when you said that, I said, well, you know, stuff about them. And then I said, whatever your concerns are, we can give you immunity, Mr. Copeland. So I didn't tell you I lied on them to get myself out of the situation, Ms. Hilton. You said you were a liar. That's what you said. You said you were a liar. Wow. They literally are suborning perjury. They absolutely are. This person, wow. Miss Bumpus, was this recorded?
Wow.
Miss Hilton is like,
No.
no, Miss Bumpus. And did he ever say that Melnick was his attorney? Miss Hilton, no. This week, when we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said, he's not my attorney. I haven't even talked to him.
So the judge is listening to all this.
Yeah.
This is interesting.
He's there. Mr. Copeland, no, I never said he's not my attorney. I said I haven't talked to him. Miss Hilton, you said he's not your attorney. You haven't talked to him. Then we continued to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone. Mr. Copeland, you didn't make me feel like I needed him, Miss Hilton. But if you needed him, we would have said, if you would have.
How would he know if he would have
exactly? We would have said to you, okay, just call him. So, I mean, that is our position. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is, not the truth.
Right, not the truth, whatever your truth is.
Whatever your truth is, that's crazy. Whatever your truth is, but you just got to answer the question. We believe that whatever your truth is what your truth is. We know what you said before. I don't know what you're going to do, what you're going to say on the stand, but we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your question. I know what you said before, and I know what you said later. I mean, I know what you said before, and I don't know what you are going to say on the stand because you and I have never went into full details about any of it. But what I don't want is you to be sitting here in custody, Mr. Copeland. You did it. Miss Hilton, I did not do it. You did it by pleading the fifth, Mr. Copeland. You told me before you went to the judge with whatever the thing called you went to him with. You told me that I can't. When I'm asked a question, I can say, I don't recall or I don't know. You told me that if I pled the fifth, something, why would I plead the fifth to something I didn't do? And I said that you don't know what I did and what I ain't do. And then you was like something, and then y'all asked for this immunity. And I was like, it was something. And then Thursday or Friday came, and then y'all go tell me, oh, we went to the judge with this, and you got to testify. If you don't testify, the judge is gonna lock you up, Miss Hilton. Right. But that was based on what you, Mr. Copeland. But I told y'all that, Miss Hilton. No, you didn't, Mr. Hilton. You said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened, Miss Hilton. And I said, I don't know what happened.
So hold on, Ike. So it sounds like she didn't record this. She kind of set the dude up.
Yeah.
She set the dude up to get him to understand. He didn't understand what she was trying to explain to him that he should do. She's giving him legal advice.
Right.
This is just all
bad. It's all
this
bad.
Is all bad. This is all bad. And the judge is listening to this.
And he's sitting there letting it go down.
That's crazy.
Letting it go down. Only you know and them know. Okay. I said, but you never said, I am pleading the fifth. You said, what if I do this? What if I do this? What if I do this, Mr. Copeland? I told you. I said, I'm going to plead you said, why would you plead the fifth to something that you know you didn't do, Miss Bumpus? So if you didn't have immunity prior to, is that what you are saying? That you feel like he didn't have immunity prior to, Mr. Copeland? Immunity came Friday night when I went to jail, Miss Hilton. The immunity only came after Mr. Melnick. Miss Bumpus, hold on, Miss Hilton. The immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. That was on Thursday evening at 6:00. Miss Bumpus, okay, Mr. Hilton. So after that, that was an emphatic, he is pleading the fifth. Miss Bumpus, Miss Hilton, we came and we got this signed. Miss Bumpus, Miss Hilton. And then Friday morning came. Miss Bumpus, okay. She must be getting paid by the word. Miss Hilton. So between Friday evening, Mr. Melnick reached out to us, said he represents him. He's pleading the fifth. Miss Bumpus, okay. And when was the last time you talked to him before Mr. Melnick got involved, Miss Hilton? We talked to him earlier that day on Thursday, Miss Bumpus. Okay. And then Hal speaks inaudibly to Mr. Copeland. Mr. Copeland, he called me, Miss Bumpus. Okay. Probably how did Mr. Melnick get involved? Is the question that we can't hear. Miss Bumpus, okay. I was just trying to get a timeline. Miss Hilton, sure, right. So we have been talking since last Friday. So I met with Mr. Copeland last Friday, I think out in the neighborhood. Then he came on Tuesday for court. We talked briefly on Tuesday, and then on Wednesday, he came, Mr. Copeland, Thursday. Miss Hilton, no, I think he only came 2 days, so it had to be Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday he came. And then on Thursday, once he left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went the next morning and got the immunity motion. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melnick came, and then we had court, Ms. Bumpus. So you are pretty much saying you didn't ask for this, Mr. Copeland. I didn't, Miss Hilton, but we gave it. He didn't have to ask for it, Ms. Bumpus. I know. I mean, he's just saying, Miss Hilton, right. He doesn't have to ask for it, but to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it, Ms. Bumpus. So if he wouldn't have said this, I'm just saying this so he can understand. I'm walking him through, Ms. Hilton. Ms. Bumpus. Would he still have had to testify, or would he have been able to plead the fifth? That's what he's saying. Ms. Hilton. If he did not have immunity, Ms. Bumpus, yes. Ms. Hilton, yes, he could plead the fifth.
Okay, I see what just happened. I see what happened. They gave him that immunity agreement, so he couldn't
Right.
plead the
So he
fifth.
couldn't, right.
But if he had a competent attorney there at the time, they would have probably said, "Don't take the immunity agreement, just plead the fifth."
He didn't have to take the immunity agreement just because they presented it to him, but
Right,
he probably
absolutely.
was not properly advised about what his rights were
Absolutely.
with respect to the immunity agreement.
Mm-hmm.
Ms. Bumpus, that's what he's trying to say. He's trying to say he didn't ask for this, Ms. Hilton, but he doesn't have to ask for it. Now that we have given it to him, because that's on us. So now that we have given it to him, it's an order. He can still choose if this is the road he wants to take, then he'll just stay in custody until
They
the trial
boxed
is
him
over.
in. They
Yep.
boxed this guy in.
And when
That's what they did.
and when we say the trial is over, every last defendant has been tried, not just these 6, the other ones too.
Wow.
Mr.
Wow.
Copeland, I done did longer time. Ms. Hilton, all right, Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you. But we wanted to put on the record, the state does not want you in custody. What the state would like you to do is purge yourself from Mr. Cole. What purge yourself mean, Ms. Hilton? Meaning that you are no longer in custody. That's not what fucking purge means. Meaning that you are no longer in custody, and the way that you purge yourself is to testify. That is kind of how it happens, and that is what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The only thing that's holding you in is you refusing to testify.
Well, she could have said it in a different way.
She could have said it 1,000 different ways, but
exactly.
The court. So you don't have any questions, any other questions? Basically, if you invoke the fifth, Mr. Copeland, I don't know who's going. I don't know what's going on. I don't trust nobody. I don't trust her word, but I don't know. No, I trust her word, but I don't know what's going on, Your Honor, Miss Hilton. This is your insurance. I don't know if you want to break that down to him, Miss Bumpus. Well, he doesn't want that, the court, but he's been given it. See, that's the challenge, Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege. But what the state decided is they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made from the state's perspective, they have made a decision to give you immunity, so you no longer can invoke your Fifth Amendment privilege. You have to testify. So that's the difference in this particular scenario, is that they have taken away. Well, you can still invoke your Fifth Amendment privilege. You still can do that, but the consequence of invoking is that you will just remain in custody. So if you're testifying, you get out of custody and you stay out of custody until you are done, Mr. Copeland. And then if I don't testify, I have to stay in until when? The court, until trial is over, until all the defendants have been. I've got these 6 that have that we have right now, and then there's another 6. Ms. Hilton, no, there's another 17. 17 for you, Bob Molly. The court, there's another 12 or thereabouts that are still outstanding in various forms or another. Mr. Copeland, can I speak with her for a second? The court reporter should have said, indicating, I'm assuming Miss Bumpus. The court, yeah, sure. Judge Glanville, assistant ADA, the court reporter, and the investigators left chambers at 10:17, return at 10:33. Mr. Copeland, my question is, I can ask you a question? Court, yes, Mr. Copeland. So my question is, so what I was just asking her was, if you ask me a question and you feel as in I was lying about it, you will lock me back up? Ms. Hilton, no. So you are saying, you say, I didn't talk to who? Demarkian? Demarkian. I didn't talk to Demarkian. Well, no, I can't talk about that because the judge is in here. You're asking, for example, if you said before that the sky was blue, and I asked you on the stand what color this is the sky, and you say, I said it was red, I'm going to say, No, back before you said it was blue. And that what you are trying to ask me? Miss Bumpus. Uh-huh. So explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? Miss Hilton. If he said he did something and he did not do that thing, Miss Bumpus. If you believe he did not, so if you believe that he's lying about that, Miss Hilton, then no. If he admits to doing something on the stand, Miss Bumpus, Miss Hilton, and he did not do that thing, Miss Bumpus, Miss Hilton, I'm going to say, if this is this the first time you are saying that, Miss Bumpus, and you have independent evidence to prove it wasn't him, then what? Miss Hilton, then nothing. What do you mean, like, Miss Bumpus? So then he will be fine? Miss Hilton, yes, but Miss Bumpus. So you are okay with him if he got on the stand and said things that weren't true? Miss Hilton, no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that is inconsistent with what you said before, then I'm going to ask you about the inconsistencies. But I expect you to tell the truth. What you go on the stand and do, I don't know. I don't know what you are going to do. I want you to tell the truth, but I will deal with you, not you saying something different in the manner that I normally do, Mr. Copeland. If I'm saying something different, right? So when the police question me, they don't question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Miss Hilton, okay, so you can say, I don't recall. That is how that works. I don't recall, Miss Bumpus. And he can say that to every single question, Miss Hilton. I would hope that that is not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do.
Well, we do know that Adrian Bean didn't recall a lot, and she didn't press him like this.
I don't know.
Interesting. Okay, so I think we'll stop at 38.
Stop at 38. How much does he have left?
I don't know. I hadn't checked. I just want to look at the comment section real quick here. See, okay. Let's see. Okay, hold on. Let's see here. Okay, Mikey said, why would anyone not cooperate with such gentle prosecution?
They're handling him with kid gloves almost.
Right. Someone said a good point. Only 56 pages on a 3.5-hour meeting. Nah, I need the recording. Uncle Paul.
But there were breaks in there. The timing is in here. So, there were different breaks. He was in custody, so they had to wait, a little bit for him to come. Let's see. Do they say what time the meeting ends? It should be at the end. This is the last day. What? Oh, this is the first day. Oh, these came out today.
Whoa. It's interesting they came out today when the judge refers the case to another judge.
Right.
So it's pretty interesting. We need that judge to have the audio recording too.
The proceedings concluded at 11:30. So it wasn't 3 hours. Well, that's only an hour.
Yeah.
Hour and a half, because he came in at 10. 10:03.
But they were already
yeah, they was doing that bullshit. They were talking to each other for half an hour, getting nowhere fast. So, hour and a half. 56 pages for an hour and a half.
I want to resume this tomorrow, to do resume it tomorrow. Let's you and I talk offline.
Okay. All right, we could pick it up. We left off at page 39. We can pick
38.
it up. 38. 38 is fine. I'm
Right, it
tired.
was started 39. Okay, good.
Yeah, I'm officially tired.
Yeah,
Y'all,
I
you can hear it in my voice.
I
Start to
too am
go.
officially tired,
Okay.
but it was good. Ladies and gentlemen, for those who have been watching, first of all, Ike,
Yes.
some of the things that 88 Hilton did, it kind of felt like, you know, the fact you were recording these visits to his, the neighborhood. Why were you recording that when other investigators have, and you had to investigate with you? Why weren't you recording what was being said?
The
Because they didn't want
investigator
to.
should have been recording what was said,
Right.
or taking notes or something to that effect. Now, sometimes you don't record what is said during an interview because you don't want to create discoverable material, right?
Hmm.
So you start writing things down and taking notes, you are creating discovery that you ultimately might have to turn over.
Brady material.
It could be Brady, it could be what's called Giglio
Hmm.
material,
Hmm.
right? Giglio is material that it can be used for impeachment purposes, right? Brady is material that is
Oh, hold on.
exculpatory.
I'm sorry. I got to put you back on screen. Go ahead. Oh,
Okay, so
so,
Brady is material that is exculpatory for the defendant. Giglio material is evidence that allows the defense to formulate impeachment material, right?
mhm.
So both of those classes of evidence, need to be turned over. But this whole idea that he told them that he had lied this previously, right? That everything he had said, I mean, I'm sure that they don't believe him, but the fact that that's his representation, they really have to take him at his word, right? Because I don't know that they have independent corroboration of anything that he said, right? Aside from Instagram which, that this is like the weakest type of corroboration. So the fact that she knows that he is going to
Take
lie.
it. Right.
Basically, he says he's a liar. Not only did I lie then, but I'm going to lie now, right? Why would you be putting him on the stand? Even if he
And
said,
why would
I'm
you?
going to tell the truth now. He lied before. He said he lied before. So you want him to get on and recount those lies?
But you present him with this limited immunity agreement. He didn't even ask for it, but
You
you
know,
knew
they
you were.
never asked for it. That's standard. That's
Okay.
standard, though. For a prosecutor, as soon as you say I take the fifth, they bring out the immunity agreement. You're not about to do that, because your
Mm-hmm.
testimony is that valuable. If your testimony is not that valuable, we don't give you immunity.
Mm-hmm.
They wouldn't give him immunity. They just let him invoke, or in, I don't know, figure something else out. Get the testimony from somebody else, get the evidence in some other kind of way. But I think it's problematic that, he told them in advance that none of this is true.
Right.
Because you have an ethical responsibility to make sure you do not put a fraud upon the court,
Mm-hmm. Mm-hmm.
right? And so the testimony should be vetted. It should be vetted, and you
Do you,
can't knowingly put a witness on that is lying.
do you think Bumpus really tried? She was asking some probing questions, not too much.
I don't. Does she do this for a living? I don't
She's
know.
she's
Or did
she's a
she
criminal
just
defense attorney. She was with the
just
prosecution's office.
started?
She
Yeah.
used to be at the
Oh,
DA's
is her
office.
so maybe her allegiance was split? I don't know. Maybe she was in an awkward situation because she was really just filling in for someone. And it's awkward when you are covering for another attorney because you don't have the tertiary knowledge that that lawyer has,
Right.
right? So it could be some of that happening, where she just is not as equipped as she would be if she was the representing counsel. So, I want to give her the benefit of the doubt because it sounded like she was in a tight spot.
Right.
You
Right.
know,
Right.
they put her in a
And
tight spot.
she was trying to get out that spot. It was
Yeah, for
clear.
sure.
Yeah.
Well, definitely trying to get out of that.
Well,
So
ladies and gentlemen, I thank you guys for staying with us. We are going to resume
on the
this
late night,
the late night. This is
let me put on my
shout out
quiet
to
storm voice.
shout out to those in California because I know you guys are
Yeah,
still
that's
up.
true. They could be up. Yeah, that's right. That's right. True that. True that.
Uh, and we have some more analysis to do with this ex parte because the judge, whoever the judge is, that will he had the recusal. This is nice. This is nice. It doesn't seem like, I don't know. I can't even say it doesn't seem like it was too much pressure, because there was some things that were happening in that meeting that the defense attorney should probably have been a part of. You know,
Yeah.
still should have been in there, because you brought up a few points. Yeah, still should have probably been in there, because there were some things that they were saying that could be tactically challenged.
My problem too is that it sounds like he told them before they put him on the stand that he was going to invoke his
Right.
Fifth Amendment right.
Right.
You know, so you shouldn't have put him on then.
Right. And he invoked the fifth right in front of the jurors.
Right. Yeah, that's problematic. But we can revisit that and the rest of the Supreme Court decisions. There are quite a few more.
We'll get into that.
More to address. So yeah. All right, people.
Appreciate everyone.
All right, thank y'all.
Yes, thank you very much. And until next time, we are out of here.
Peace. It's your girl Ike here. You know I love you. I really do.
So do I. Peace.